So welcome everyone to part one of our three-part not-for-profit forum, kindly put together by Aon, Jenkins Legal and Advisory, and Cutcher & Neal Accounting and Financial Services. Workplace risks and strategies for success forum is the subject for today. At Aon, we specialise in risk management, and what we like to do is help businesses make better decisions and make them with confidence. So I've got the privilege of working in our local branch in Newcastle with a great team, and we're present in 120 countries, so we get to leverage off of that for our clients in our local area and deliver world-class solutions for all of our clients, which is awesome. First up, we're going to hear from Marguerite Walsh from Jenkins Legal and Advisory, and Marguerite's going to take us through wage theft law, termination, and just give an overview on that. Then next up it's Tereska Zai from Aon, and Tereska will be covering off the consequences of non-compliance relating to psychosocial risk. And then last but not least, we've got Elise Stones from Cutcher & Neal Accounting and Financial Services. And Elise is going to be covering off reducing payroll risk and just going through the processing and some technology around that.
Today we're going to spend a small amount of time on the new wage theft laws and a larger chunk of time talking about terminations. The amendments to the Fair Work Act, dubbed the wage theft laws, commenced on 1 January 2025. Given that the term wage theft has been used colloquially for many years now, some of us might be confused about what these new laws actually relate to. In short, the previous legal framework didn't specifically apply to theft at all. It dealt with the underpayment of wages via civil remedy provisions of the Fair Work Act. However, with the Fair Work Ombudsman recovering more than $1 billion in unpaid wages and entitlements in recent years, wage theft now constitutes a criminal offence. The Fair Work Act requires employers to pay their employees for the performance of work, in full, in money, and at least monthly. Awards and enterprise agreements also set industry and job-specific rules regarding the payment of wages. Intention was irrelevant to establishing an underpayment under the previous laws, and this prior regime applied to innocent mistakes all the way through to deliberate conduct. Previously, personal liability could attach to a person who was involved in a contravention. Directors, executives, HR managers, and even third-party advisors. They've all found themselves personally named in underpayment claims as a result. When it appeared that the original laws were perhaps not having the desired impact on employers, the Fair Work Act was amended in 2017 to include a new category of serious contraventions. These serious contraventions attract 10 times the maximum penalties which apply under the original laws, and originally arose in relation to deliberate underpayments committed knowingly and as part of a systematic pattern of conduct. However, from the 27th of February 24, the threshold changed, and the definition of serious contravention now covers conduct committed knowingly or recklessly. This new focus on reckless behaviour means that employers are exposed to much higher penalties where it's evident that they've not paid proper attention to their wage obligations. Currently, the maximum penalty applicable to a serious contravention is $4.695 million for each contravention committed by an employer who has over 15 employees. From 1 January this year, wage theft will arise where an employer intentionally engages in conduct which results in a failure to pay an employee an amount due to them. Under the amended Fair Work Act, this means that intentional underpayment of wages will constitute a criminal offence. Employers will commit an offence if they're required to pay an amount to an employee, such as wages, or for the benefit of an employee, such as super, and they intentionally engage in conduct that results in their failure to pay those amounts to or for the employee on or before the day it's due. The Fair Work Ombudsman is responsible for investigating suspected underpayment offences, noting that severe criminal penalties apply, as you can see on the slide. In addition to criminal penalties, the recent closing loopholes amendments to the Fair Work Act also increase civil penalties for wage underpayments. For employers who have more than 15 employees, the maximum penalty can be 3 times the value of the underpayment or the relevant penalty unit amount. And with the lowering of the threshold for a serious contravention, this means that greater civil penalties will also apply in the case of intentional underpayments, as these will undoubtedly fall into the new definition. The Fair Work Ombudsman will be responsible for investigating potential wage theft and then deciding whether to refer a matter for prosecution. While the new laws include safe harbour provisions, which encourage employers to voluntarily disclose potential wage theft issues to the Ombudsman in the hope of entering into a cooperation agreement rather than being prosecuted, the Ombudsman will have complete discretion as to whether it goes down that path. So let's have a quick look at the intention element of the new wage theft laws. The Commonwealth Criminal Code confirms that intention is established where a body corporate expressly, tacitly or impliedly authorises or permits an offence. Therefore, to establish the intention element of the new wage theft laws, such authorisation or permission will be established where a board of directors or high managerial agent intentionally, knowingly, or recklessly carries out the relevant conduct, or expressly, tacitly, or impliedly authorises or permits the commission of the offence. Or it will occur where a corporate culture existed that directed, encouraged, tolerated, or led to non-compliance, or where the employer failed to create and maintain a corporate culture that required compliance. While board members and other individuals involved in underpayments were already exposed to potential personal liability under Section 550 of the Fair Work Act, the conduct of boards and high managerial agents is now a specific focus of the new wage theft laws. The Criminal Code defines a board of directors as the body, by whatever name it's called, exercising the executive authority of a body corporate. High managerial agents are employees, agents, or officers of a body corporate with duties of such responsibility that his or her conduct may fairly be assumed to represent the body corporate's policy. In cases involving senior managers and key decision makers in payroll and HR departments, we expect that it will be easier for courts to associate their conduct with that of the employer. In other cases involving other employees, it'll be a question of fact as to whether an employee is a high managerial agent, and therefore whether their conduct should be taken into account to establish intention. And this will involve an analysis of the individual's duties and delegations. So what contributes to an employer's corporate culture? While it will likely be more straightforward to gather evidence of the actions or inaction of directors and high managerial agents in wage theft claims, evidence of the corporate culture within an organisation is a less tangible concept. The Criminal Code defines corporate culture to mean an attitude, policy, rule, course of conduct or practice existing within a body corporate. In the Financial Services Royal Commission, Commissioner Hayne described corporate culture as what people do when no one is watching. In ASIC and AMP financial planning case, the judge emphasised that whatever corporate culture means, it must transcend simply putting in place expensive systems, or it must be more than persons whose titles include terms such as governance and compliance. So tying these approaches together, it's clear that employers not only need to be able to point to the policies, procedures, personnel and structures that they have in place to demonstrate their commitment to wage compliance, employers must also show that these measures are appropriately implemented and continuously reviewed in practice. Further, separate to evidence of what conduct was directed or encouraged by an employer, the concept of what conduct was tolerated within an organisation is a noteworthy feature of the intention element. That is, how an employer responds to wage discrepancies and inquiries, as well as its general support and resourcing of its payroll function, will also be relevant to whether a corporate culture of compliance or non-compliance existed. Not only would a finding that a corporate culture of non-compliance existed give rise to real risk of wage theft, it could also be highly damaging to an employer's internal and external brand reputation. A wage theft prosecution under the new laws will involve analysis not only of an employer's policies, practices and procedures, but also the conduct of its board and its high managerial agents. While many organisations will already have a very strong payroll compliance program in place, the onset of new wage theft laws should encourage all businesses to take this critical aspect of their operations very seriously. Some things you can do to assist with compliance today. 1. Ensure that your payroll team and key HR personnel receive up-to-date training. Employment law is ever changing. Putting to one side all of the closing loopholes amendments that have come into force since December 23, regular developments also arise from case law and changes to modern awards. Therefore, investing in training is absolutely essential. If legal developments are missed, this can mean that your wage practices become outdated and non-compliant. While we appreciate how busy payroll and HR teams are, prioritising training and continuous improvement will provide a strong example of your organisation's commitment to wage compliance. We recommend that you review your governance structure and your systems. Given the specific focus on the conduct of boards and managers within the new wage theft laws, it's not appropriate to delegate wage compliance to your payroll or HR team and dismiss this as an operational matter. Instead, board members and managers need to be able to demonstrate their proactive commitment to wage compliance in order to be in a strong position to defend any suggestion that they authorised or permitted an offence. Organisations should be reporting to their boards on payroll compliance initiatives and reviews. And managers should have clear procedures in place for their teams to escalate pay issues so that they can be properly and promptly remediated. Our third recommendation is that you conduct regular payroll reviews. Rather than waiting for a complaint or an issue to arise, we recommend regular proactive payroll reviews so that you can be satisfied that your wage practices are compliant. This can involve organisation-wide reviews spanning the full 6-year liability period for underpayments, or targeted reviews of employees who work in roles which might attract complex overtime and penalty rate provisions, for example. We note that some awards require periodic pay reconciliations for employees who receive annualised salaries, so this may actually be a legal requirement for some businesses already. Fourthly, review your pay rules regularly. Pay rules form the basis of your payroll system. Your pay rules need to be accurate and fit for purpose to make sure your staff are not underpaid. Given the constant changes to awards, employment legislation and case law developments, pay rules require regular review, and a set and forget approach just simply won't cut it. We also recommend that pay rules are reviewed externally. Too often pay rules are left unchanged due to a reliance on past practices or perhaps overlooking a development in the law. A review by a fresh set of eyes will almost always uncover areas for improvement. And finally, have a clear plan in place for dealing with pay inquiries and any approach by the Fair Work Ombudsman. Many organisations have clear protocols in place for dealing with serious incidents in the workplace or approaches by regulators, such as in the work health and safety context. Given the seriousness of wage theft allegations and the risk of criminal liability under the new laws, we recommend that a similar protocol is adopted for responding to wage theft claims and inquiries by the Fair Work Ombudsman. Specifically, you should ensure that you have a clear plan in terms of who needs to be notified of a wage theft complaint, who will be your organisation's spokesperson, when to seek legal advice, and how and when to communicate with staff to ensure consistent and clear messaging. Understanding the powers of Fair Work Ombudsman inspectors will also be important to ensure that there's an appropriate balance between assisting their investigation but not readily conceding issues that might require further analysis. Please feel free to reach out to any of our 3 teams in the room today regarding the wage theft compliance and managing risk in your organisation following the introduction of the wage theft laws. Now, from wage theft to terminations. The High Court recently said, "It's been described as a social reality that a person's employment is usually one of the most important things in his or her life. It gives not only a livelihood, but an occupation, an identity, and a sense of self-esteem. And an unfair process of termination could affect all 3 of those interests." Termination is the formal cessation of a worker's engagement. It takes many forms, including sacking someone with notice, terminating someone because they didn't pass their probationary period, making a position redundant, performance management resulting in a decision to dismiss, summary termination, negotiating a mutually acceptable parting of ways. It also looks like medical retirement, death of an employee, expiry of a fixed-term contract, repudiation of the employment contract, abandonment of employment, and frustration due to long-term illness or injury. I wish we had time to go into all of these, but let's just talk about 3 for the purposes of today. Firstly, let's talk about terminating someone because they didn't pass their probationary period. Probationary periods are used in practice to make sure the new employee is the right fit. Simply put, you want some sort of cooling off period to make sure the person you've chosen from your selection process is the person who can do the job you need them to. A probationary period offers this try before you buy scenario where the employee is engaged, but you've included a contractual term allowing you to be able to terminate within a certain period of time simply because things aren't working out. Simple, right? I want you to consider the following. Your organisation needs a new CEO. You go through the process, you choose someone you think is perfect, hire the person, and include the standard 6-month probationary period in their employment contract given you aren't a small business employer. Your new CEO is doing fairly well and starting to get the hang of the job. You're almost 6 months into the new CEO's engagement. You receive a complaint of sexual harassment from one of the other employees, alleging that the new CEO made inappropriate comments and maintained prolonged, unnecessary eye contact that made the complainant uncomfortable. The new CEO denies the allegation of sexual harassment, but admits to complimenting the complainant's appearance. You stand the CEO down and appoint an external investigator. The day before the CEO's probationary period is up, you check in with the investigator, who advises that they haven't yet finalised the report, but indicates that the allegations are substantiated on the balance of probabilities. Given the impending end of the probation and the fact that the following day the CEO will have completed the minimum engagement period, making them eligible to file an unfair dismissal claim, you arrange an emergency meeting of the Executive Committee late that afternoon, and it's decided at that meeting to terminate the CEO's employment. What are your thoughts about this process to terminate the CEO?
That's probably what's going to happen.
Yep. Is there anything that you would have done differently?
Oh yeah, I would have, but I'm just saying in the real world. Not supporting it, but I'm just saying.
So in the case of Debussy and Australian Federation of Islamic Councils, the court found that there was no reasonable explanation for the rushed late afternoon meeting of the Executive Committee. The fact that the CEO had already been stood down and the unfinalised status of the investigation report led the court to conclude that there was no strong evidence indicating why this haste was necessary. Therefore, the judge held that a substantial and operative reason for terminating the CEO's employment was to deny him his future workplace right to bring an unfair dismissal claim, and this constituted unlawful adverse action. He granted interim relief, reinstating the CEO to his former position. The key takeaway in this decision is that the court held adverse action undertaken to prevent an employee from exercising a future workplace right. In this case, dismissing him to prevent an unfair dismissal claim is unlawful and contravenes the general protections in the Fair Work Act. Probationary periods are useful tools for employers and employees alike to test whether each party is a good fit for the other. In many cases, terminating employment during the probationary period is a straightforward exercise and relatively low risk. However, this case provides a warning that termination during the probationary period, particularly if the termination occurs close to the end of the minimum engagement period, can have significant legal risks which need to be managed appropriately. Our second termination scenario for today, making a position redundant due to a downturn. I want you to imagine it's 2020 again and your business has been impacted by COVID. The financial impact on your business is such that your turnover is effectively reduced to zero. Nothing. You've got enough squared away to keep the business afloat for a certain period of time, but the trouble with this COVID thing is that you simply don't know how long you're going to be affected for. Your employees are highly unionised. You continue to maintain the status quo for a couple of months before starting to make the tough decisions. One of these tough decisions that you make is to outsource a section of your operations to third-party suppliers. You consider bids from various suppliers, including a bid from the union which relates to your existing workers. You're concerned that going with the union bid will present potential industrial action, which is a risk you just can't fathom in the current financial crisis that the organisation is in. So, you go with the cheapest outsourcing option, you purposely decide to reject the union bid to avoid potential industrial action in the future, and you make the roles in that particular section of your business redundant. Can anyone see any issues with this scenario? Is there a problem with factoring in the potential for the union employees to participate in industrial action in your decision-making process?
Yeah, that doesn't sound good.
So in 2023, in Qantas Airways Limited and the Transport Workers Union of Australia, the High Court confirmed that employers will contravene the general protections provisions if they take adverse action against employees in order to prevent them from exercising a future workplace right. While Qantas had sound commercial reasons for the outsourcing decision, including that the union bid was not financially competitive compared to the other third-party ground handlers, its evidence failed to prove that preventing the employees from engaging in protected industrial action in the future was not a substantial and operative reason for the decision. The High Court said that it will be unlawful for an employer to take adverse action to prevent employees from exercising a workplace right they'll have in the future, even though that workplace right does not yet exist at the time that the adverse action is taken. The High Court also commented that a decision maker's mere knowledge or consideration of the existence of a future workplace right will not automatically result in a contravention unless preventing the exercise of the future workplace right is a substantial and operative reason for the decision to take the action. This can be complicated, and this is the reason we are continuously urging our clients to reach out before taking action that might lead to termination. For our third and final scenario today, let's talk about summary termination. An employer has the right to dismiss an employee summarily, that is, without notice, in circumstances where an employee engages in any act or omission that amounts to serious misconduct. Regulation 107.2 of the Fair Work Regs defines serious misconduct to include willful or deliberate behaviour by an employee that is inconsistent with the continuation of the contract of employment, conduct that causes serious and imminent risk to the health or safety of a person or the reputation, viability or profitability of the employer's business. Conduct that is serious misconduct is then further defined to include the employee in the course of the employee's engaging in theft, fraud, assault or sexual harassment, the employee being intoxicated at work, and the employee refusing to carry out a lawful and reasonable instruction that is consistent with the employee's contract of employment. Now let's consider the facts before you. You have a permanent employee who's worked for you for 9 years. This employee regularly travels for their role and you find them to be competent, although quite assertive, maybe even aggressive in their responses to work requests or queries at times. You've never formally raised this perceived aggression as an issue, and the employee has an unblemished record of meeting performance standards. On a normal work trip, the employee experienced difficulty sleeping due to noise in his hotel. He called reception at around midnight, made a complaint, and was moved to a new room a short time later. The hotel worker who dealt with the employee knew some of your other employees and told them that he was aggressive and raised his voice when complaining in the middle of the night. And then, when he checked out the next morning, he didn't say a word, but simply threw the keys on the reception desk and walked out. She said she found her interactions with him intimidating and humiliating. The employees who heard this report from the hotel worker let the employee's manager know. The employee's manager said she wasn't surprised because she'd experienced this sort of behaviour from him before. Following this trip, the employee commenced a period of planned annual leave, so the company waited until his first day back from leave to meet with him. During this meeting, they provided him with a stand-down letter alleging that he had breached company policies and requiring him to attend a disciplinary meeting in a week's time to respond to a complaint regarding serious misconduct. The employee provided a written response to this letter in which he denied any allegations of misconduct. The disciplinary meeting was held and the employee wholly denied the hotel worker's version of events. The organisation considered both his written response and the response he provided in the meeting. His manager said that it's likely the hotel worker's version of events was accurate based upon her previous observations of the employee's perceived aggressive conduct. Therefore, 3 days later, the company terminated his employment by issuing a formal letter of termination, which stated that the company considered that on the balance of probability, he did behave in the manner described by the hotel worker and the company considers this behaviour to be serious misconduct. Does anyone have any thoughts on this scenario? Was it a situation that warranted summary dismissal? No? No.
He was woken up at midnight.
Yeah. And what do you think of the process that the company followed?
There was none.
What if I told you that this employee filed an unfair dismissal claim and settled with the employer for the maximum compensation payable? Then, some 5 years later, the employee was diagnosed with a major depressive disorder and an adjustment disorder with depressive mood. He was found to have no capacity for work in the foreseeable future. It was at this time that he commenced proceedings in the Supreme Court of Victoria. The primary judge made findings in favour of the employee with respect to the hotel incident and held that the process which led to his termination was unfair, unjust, and wholly unreasonable. To simplify the issues in the interest of time, the process of his termination was found to be deficient because the company had referred to its disciplinary policy in its employment agreement in a manner that made the policy contractually binding. The disciplinary policy required the company to provide the employee with a letter setting out the allegations, and as you'll recall, all they gave him was a stand-down letter and a meeting in which to defend himself. Therefore, the company was found to have breached its own policies, which amounted to a breach of contract. There was also quite a bit of consideration given to the manager's biased perception of the employee's previous aggressive conduct, which had never been addressed with him and had never been raised previously in any forum, but which clouded the decision-making process despite the company never giving the employee the opportunity to respond to that particular allegation or address the issue. Subsequently, it was found that the employee's psychiatric injury was reasonably foreseeable as a consequence of the termination process that the company followed. The primary judge found that the party should be taken to have reasonably had in contemplation that the risk of distress or potential psychiatric injury was a serious possibility in the event of a breach of contract. Accordingly, the Supreme Court of Victoria ordered damages for breach of contract for an amount just shy of $1.5 million, including an amount for psychiatric injuries. This was overturned on appeal, but was upheld in the High Court decision of Alicia and Vision Australia, which was handed down in December 24. There's so much we could discuss in respect of summary termination, but the key takeaways from this scenario in this case is that, of course, employers have a right to lawfully bring an employee's engagement to an end. However, employers may be liable for psychiatric injury arising from the circumstances of the dismissal, depending on the contract terms and the facts. Therefore, it's important for employers to exercise care and remain cognizant of the terms of the contract and the important role that procedural fairness plays in a termination process. These facts taken from the High Court case of Alicia and Vision Australia, a case that undoubtedly created a significant development in the law concerning an employee's ability to seek damages associated with the manner of their termination. In practice, I think every Fair Work claim that I've had on my desk since this decision has actually referenced the decision and the issues of contractual terms or managerial bias or procedural fairness. However, we should be mindful that this case turned very much on its own facts. Therefore, there's some things I'd like you to think about following this decision. 1. Do your employment contracts use language that clearly exclude policies from forming contractual terms? Employers must be mindful that if their employment contracts include specific disciplinary or termination procedures, failure to adhere to these procedures may expose the employers themselves to liability for resulting harm, including psychological harm. Secondly, please ensure that reasons for termination are clearly documented and communicated to employees. Failing to provide clear grounds for dismissal can lead to legal challenges. But please make sure your reasons don't expose you to risk. If in doubt, just pick up the phone, give us a call, we'll discuss the approach. And thirdly, a procedurally fair termination process is critically important. Please ensure that employees have a fair opportunity to respond to allegations and that the outcome of a disciplinary meeting is not predetermined or based on additional matters not put to the employee. So let's talk a bit about procedural fairness. Procedural fairness in the context of terminating an employee's engagement refers to the fair and transparent process that employers should follow before making a decision to terminate. This concept is rooted in the principles of natural justice and is a critical consideration in determining whether a dismissal is unfair under employment law. You might ask me what procedural fairness looks like in practice, to which I'd give you the stock standard lawyer response of, it depends. Broadly speaking, it requires you to set out a clear and transparent process for dealing with workplace issues as and when they come up. And I can't stress this timing issue enough. Please don't take the ostrich approach and hope for the best. Deal with things at the time that they occur. I once had a wise HR friend of mine give me some management coaching for my then management role in the public sector. And she told me that being clear and upfront can be done in a manner that is respectful and kind. If you've read Dare to Lead, you'll be familiar with Brené Brown's similar position, that to be clear is to be kind. And you know yourself that it's only once you're made aware of an issue that you can engage with it and address it in any aspect of your life. So while it's definitely uncomfortable to have these conversations in the workplace, it really is in everyone's best interests. Contrary to popular belief, there's no rule that an employee must be given a certain number of written warnings before being dismissed for poor performance or misconduct. But over the years, the various industrial tribunals have frequently upheld unfair dismissal claims by employees who've never been given a chance to improve their performance. If an employer does have formal policies and procedures for dealing with disciplinary matters, it must be careful to ensure they're actually followed. Failure to abide by agreed procedures can amount to a breach of the employment contract, as we saw in Alicia and Vision Australia and the various cases that came before it. It's notable that legislation prohibits the dismissal of an employee for certain prescribed reasons, such as an employee's gender, race, or membership of a union. The one that immediately comes to mind is the general protections regime set out in Part 3.1 of the Fair Work Act. There are also provisions that allow workers to seek redress on the basis that their dismissal was harsh, unjust, or unreasonable. So whilst there's no formal requirement to provide a certain number of warnings or follow a certain mandated procedure to terminate an employee, the practical effect of these protective laws is to require a measure of fairness in dismissal. An employer who fails to follow a procedurally fair process for termination risks the employee bringing a claim. There's no way to completely eliminate the risk of an employee making a claim against their employer if they are terminated. Whilst there's no action that an employer can take that will prevent an employee from bringing a claim, it's important that when employers are contemplating termination, they ensure that they've protected themselves and placed themselves in the best position to defend any potential future claim. Firstly, unfair dismissal claims. Under the Fair Work Act, unfair dismissal occurs when an employee is terminated in a manner that is harsh, unjust, or unreasonable. It also includes situations where the dismissal is not a case of genuine redundancy or is inconsistent with the Small Business Fair Dismissal Code. Some key points for you to know about unfair dismissal. Employees must have completed the minimum employment period of 6 months for businesses with over 15 employees or 12 months for less than 15 employees. Employers must earn less than the high income threshold or be covered by a modern award or enterprise agreement to be eligible to file an unfair dismissal claim. Employees can lodge an unfair dismissal claim with the Fair Work Commission within 21 days of their dismissal. The Fair Work process usually involves voluntary conciliation and, if that goes unresolved, a formal hearing. The Fair Work Commission considers whether the dismissal was harsh, unjust or unreasonable. If the Commission finds the dismissal to be unfair, it can order remedies such as reinstatement or compensation. Special considerations also apply to small business employers under the Small Business Fair Dismissal Code. The Fair Work Commission publishes statistics on unfair dismissal claims from time to time, and the most recent stats that I've read state that unfair dismissal claimants generally awarded 5 to 7 weeks compensation. The next most common claim we see in practice is a general protections claim. Under Part 3.1 of the Fair Work Act, general protections claims are designed to protect workplace rights, ensure freedom of association, and provide protection from workplace discrimination. These provisions aim to prevent adverse actions taken by employers against current or prospective employees or independent contractors due to the exercise of workplace rights or participation in industrial activities. A general protections claim can be made on numerous grounds. Some of the most common grounds are set out under sections 351 and 340 of the Fair Work Act, but there are various grounds, and broadly speaking, these include claims on the basis of workplace rights. Employees have certain rights under workplace laws, awards and agreements. These include the right to make a complaint or an inquiry about their employment, the right to participate in proceedings under workplace laws, and the right to be free from discrimination. These can include claims on the basis of adverse action. This includes actions such as dismissing an employee, injuring them in their employment, altering their position to their detriment, or discriminating between them and other employees. And it also covers threats to take these actions. It can include claims on the basis of freedom of association. Employees are protected in their right to join or not join a union and to participate in lawful industrial activities. And it can include claims on the basis of protection from discrimination. The Act prohibits discrimination on various grounds, including race, colour, sex, sexual orientation, age, physical or mental disability, marital status, family or carer's responsibility, pregnancy, religion, political opinion, national extraction, or social origin. In making a general protections claim, the employee selects which section of the Fair Work Act the employer contravened. Notably, once the employee files the claim, there is a reverse onus of proof. This means that the employer is presumed to have taken the action on the prohibited grounds unless the employer can clearly demonstrate that this is not the case. An employee can bring a general protections claim during the course of their employment or following termination. The key risk for employers in a general protections claim is that the compensation that can be awarded to an employee is uncapped, exposing the employer to a potentially high financial risk. This is different to an unfair dismissal claim, which has a maximum compensatory amount of 26 weeks' pay. One final quick point to note on general protections claims is that they can be brought by any current employee, a prospective employee, including individuals who have applied for a job and believe they were not hired due to discriminatory reasons or because they exercised a workplace right. And in a recent extension of these provisions, they can also be brought by independent contractors. And in the interest of saving time this morning, I won't delve into other types of claims like discrimination or workers' compensation and psychosocial injury claims. Tereska will talk about the latter shortly. I just want to acknowledge that your job is a big one and the risks are huge. On that note, it's important for you to know that I see you. I see you driving your organisation forward, implementing a change agenda, keeping a finger on the pulse of your corporate culture. I see you making the tough operational and financial decisions required in your day-to-day. I see you juggling the demands of your role, mentoring your middle managers, and trying to take everyone on this journey with you. I also see your middle managers, because while most of the people in this room have an absolutely enormous role, your middle managers, those people stuck managing their teams and your expectations, are sometimes your key infantrymen in keeping ahead of all the stuff we're speaking about today. These middle managers should not be forgotten. And in fact, I encourage you all to take stock of their skills and training and make sure they understand everything we've spoken about and will speak about today, because middle managers are a real pressure point in employment law. The key takeaways I want you to carry with you as you go about your day. 1. Wage theft. Review your current payment systems and processes. Elise will talk a bit more about some of these, but reach out to your accountant and make sure you're on top of this. Give our team a call if you aren't sure of your obligations or you need help interpreting an award or agreement. Number 2, make sure your employment agreements are up to date. If you haven't looked at them closely in the last 1 to 2 years, it's vitally important that you take stock of them today. So much has changed in employment law over the last little while. Similarly, make sure you're keeping up to date with changes to any modern award that applies to your workers. Let us know if you're not receiving the Jenkins Employment Law newsletter in your inbox every week, and we'll get you on that list to help you with some regular reminders. Number 3, establish your process for dealing with terminations. Number 4, get advice before you terminate and going through the pointy end of the process. And number 5, if you do need some support in the day-to-day, we offer general employment matters to employers where you can have our employment law team on call to assist you with those curly legal questions as and when they come up. It's your business, your people, your success. This is the stuff we're passionate about. We really want to see you succeed, and that success starts with your people. Termination is hard, there's no doubt about it. Please feel free to reach out following the conclusion of this morning's presentations if you have any questions. Otherwise, please feel free to email or call if there's anything I've touched on this morning that you'd like some more information about. Thanks for your time and attention.
My name is Tereska, I'm from Aon, and today I'm going to go through a 30-minute blitz session on what you need to do under work health and safety to comply with your legislative requirements when it comes to especially meeting the psychological health and safety issues or hazards and risks in the workplace. So I'm sure it is a term that everyone has used or seen in the last 15 to 18 months, psychosocial hazards, psychosocial risk, psycho something. I just want to quickly touch on your duty of care. Don't expect you to read all of it right now because I'm going to walk you through it. But the reason it's dense is because they're going to email it out to you, and it's got a number of links that's going to be very practical and helpful. So hopefully it's a resource that you can use for the next 12 months until I see you again next year and tell you otherwise. So we are going to go through your duty of care, your obligations, what is a due diligence, how do you meet your due diligence, and what is the ramification of non-compliance throughout the story. And then I'm going to walk you through what's happening in New South Wales, Queensland and Victoria, because that's where the most amount of changes have occurred in the last 6 months, and tell you what the regulatory bodies are looking for. So safe work, safe work. They tend to just want to confuse me. And then what does evidence look like when it comes to actually any of the investigations or improvement notices that may come your way if you have a visit from the regulatory bodies. Then I'm going to walk you through some of the recent case law that's come out, the theory behind the prosecutions, and the sections of the law is very relevant to any organisation. So I'm going to walk you through 3 different case scenarios, and then I'm going to quickly go through what you can take away from this as well. So I covered duty of care in more detail last year. I apologise to those who haven't been here, but the summary is right there. Your primary duty of care, there's 9 areas there that's listed for you, but I like to just summarise it into 3 or 4 main parts, which the first and foremost one, as an employer or as a C-suite, what is our duty of care? To ensure that we provide a safe and healthy workplace for our employees. Yeah? Anyone who didn't know that? No, everyone knows that. Yeah, so we must provide a safe work environment, physically, psychologically. So then how do we do that? Well, we do that by providing a safe system of work, of how you actually do your role. It's not just enough that you hire the right experienced people or the experts in the job description or in the industry. You also still must supplement their employment with safe systems of work. What do you think I mean by that? Yeah, safe from harm. So things like procedures, policies. We have a lot of youth workers, support workers, carers who are part of our employment. They might need safe work procedures. Who deals with violence and aggression from our clients? If you do, what would you provide to your employees to challenge that? I need you guys to talk to me. Training, yeah, training. Supervision, anyone dealing with young children who have behavioural issues in disability services, what's the plan that we have in place? Behaviour management plan, yeah, things like that. These are systems of work, procedures, protocols and processes that help us to do our job effectively. So that's what I mean by safe systems of work. We also must make sure that we have adequate training, like the gentleman over there said, and also that we consult with our workers on any kind of topical issues or things that are going to impact on their ability to work. And that's what I want you to take away here today when I say consult. Consult isn't just about me telling you guys that it's Black Sox Day today. It's about telling you that there are going to be some changes, or we would like to strategize with you on changes that are going to directly impact on your work. So you don't have to consult with them about anything and everything. It is relevant to their work remit is what we're trying to concentrate on. What else do we have to do? We have to make sure that we have incident reporting, risk management principles and hazard identifications in place, which everyone does, whether it be a manual or electronic format. So you can see here, I'm not going to read all of that, but under the section 27 of the Work Health and Safety legislation, it actually spells out for you what you actually need to do. And it's on the test of reasonable person. A reasonable person test is, say, I'm a client manager at Aon. Anyone who's off the streets who might be in the same role, expertise and experience, if that person would either make the similar decisions of me. So what does an average person who has the same experience of me or same expertise as me would make a decision on? So that's the reasonable person test, and which also applies to reasonable steps test as well. What would an average Joe Blow in a similar situation do as well? We want to also make sure that businesses are actually doing their very best to try and eliminate or mitigate as far as reasonably practicable anything that is hazardous and anything that poses a risk. And I say that by not defining anything that is psychosocially hazardous. It's anything that is hazardous. Psychological health and safety issues can be impacted by physical issues as well. Yeah, would you agree? How many of you have experienced employees who went on workers' comp for a physical injury, either due to mismanagement or the duration of the medicals and things like that, it turned into a secondary psych issue? Ever heard of that terminology? Physical injury turned into a secondary psych issue. So you can see, we need to see, as you can see here under the third heading, we need to manage psychological health and safety issues as an intertwined, embedded issue in the workplace. It's not just, manual handling, what's that? What's manual handling?
Anything that involves working with your hands.
Yeah, hands or your body, yeah. So musculoskeletal issues. Manual handling is physical health. So people might just go, our manual handling procedures covers it all. Does it actually cover any kind of residual psychological health and safety impact that it might have if you are exposed to too much manual handling? So can you see how it is actually embedded and intertwined and one cannot get away from each other? And that's why what we need to take away as an employer, we need to make sure that everything that we do for our workplace and for our workers consider both the physical and the psychological impact of the work that we do. Some of the other ones are things like, you need to have return to work processes. Very, very recently under the workers' comp law, there has been an update where the Comcare inspectors and CERA inspectors are also looking for whether your return to work processes have actually actually considered psychological health and safety impact of that person's return to work. Have you guys heard of that update? So when you have a suitable duties, when you have a worker returning to work and you as a manager sign off on their suitable duties, you must also consider under that documentation what kind of psychological impact is going to be it can happen to that employee returning to work, especially if they have gone off work due to psychological reasons. So it's not just a physical return to work process, 2 days a week, 3 hours a day. You must also consider the impact on the team, impact on the team's impact on the person, and the environment and the trauma that they might suffer on the first day back. Do you have a person waiting for them at reception? Do you have a person waiting for them at the car park so that they can physically ease into the building without having that trigger of returning to work for the first time? Just some statistics for you. I did look up these numbers on the 12th of March. They did give me the number of claims in 2022 and 2023, but Safe Work Australia has not yet updated the monetary value of those claims, so I've just put that in there for you. But just very quickly explaining this beautiful slideshow that took me 2 days to create, because I'm not Excel driven. As recently as 2021 and 2022, we had 12,231 mental health claims in the workplace, in any organisation. So this is just mental health, not just in not-for-profit or agricultural or things like that. In every workplace in Australia, we had over 12,000 claims. Now, compare that to how much that claim cost yearly for a business. $65,000 per year of the number of claims that they've got, which is a significant jump from 10 years ago where it was 30,000. So now it's over, I think it's about over $72,000 now for 2023. But yeah, 2.5 times the jump. And no doubt, we're not going to just have one workers' comp claim in our workplace, are we? Who can confidently say that they've got about between 5 and 10? Yep, 10 or more? Anyone with 10 or more? So that's $650,000 for you guys. Not you guys in personal, like, you know. So yeah, $650,000 for 10 or more every year. That's every year. And this is a not-for-profit forum, yeah? I've come to the not-for-profit. Yeah. Like the whole point of not-for-profit is that you don't have profit. So do you have $650,000, you know, to pay this? Not only are you paying $650,000, you're also losing them in terms of their ability to work. So an average person has 4 weeks annual leave plus 2 weeks shutdown, that's 6 weeks. An average person has 46 weeks of work. And then if you're sick for 10 days, that's 44. But you can see here, an average person on a claim is off work for 37 weeks for a mental health issue. So what was the maths again? 44 weeks that I'm able to work, and of that 44 weeks, I'm only able to work for 37 weeks. So let's have a look at what's happening in New South Wales. Every one of us, we're in Newcastle, we're in New South Wales. Back in October last year, they have updated their strategy on how are they going to support businesses. So basically, in October 2024, they said, we have given you ample time to be aware, get the guidance, get the training from our organisation and our inspectors and our advisory support to get it right in your workplace. Now, after 4 years, we need to start to see how well that's been implemented in your workplace. So they're starting a compliance split. So what they're going to do between 2024 and 2026, they're going to target about 1,000 businesses in 4 main areas: social assistance and community support, education. So part of that is our industry as well. Yeah, we've got schools and whatnot. They're also targeting public service, so yay for federal and state government. And the 4th one, I can't remember at the moment. I think it's anyone with young and vulnerable workers. For that diversity, equity and inclusion as well. So what they're doing is they're actually going to target 125,000 businesses of 25 employees or more on how well you have set up your ability to manage psychosocial issues in the workplace. Very ambiguous, very broad statement there. Let's see what Queensland's doing. As early as 1st of March this year, Queensland work health and safety laws have changed where they are now requiring employers to have written preventative plans on the actual single topic of sexual harassment in the workplace. So sexual harassment and gender and sex-based harassment in the workplace. So if you have any officers in Queensland, if you have any workers working in Queensland, even though your head office might be in New South Wales, you need to be able to comply with that law and actually have done your risk assessment and preventative plans on sexual harassment. Again, on the slide, when you get the PDF file, those links will work for you. If they don't shoot the messenger. Just look up QLD, sexual harassment preventative plans in the office. But I have tested it, so it should work. And in Victoria, this was just announced about 2 weeks ago, but the implementation won't occur till about 1st of December this year. They've also said that we are going to implement written preventative plans, but Victoria decided to do that for 5 top priority mental health conditions and psychosocial hazards in the workplace. So Queensland is just sexual harassment and sex and gender-based harassment. Victoria, you need to have written preventative plans in increased work demand, exposure to traumatic events, sexual harassment, bullying, So those top 5 psychosocial hazards that the regulator has recognised permeates in workplaces, they're asking you to write preventative plans. The OHS regulation has been passed in Parliament. It'll be assented on the 1st of October, I believe, and that's why the implementation's not till 1st of December. But again, the site is there for you to access. Got to check my time. So when I said that that was a very ambiguous statement, what are they looking for to see how well you have set yourself up for meeting the psychosocial hazard requirements in the workplace? This is what they're looking for. Any given day, an inspector or an investigator can come into your workplace. They can even come in due to audit issues or other physical health issues that they might have been privy to. And then at the time of visit, they'll just turn around and go, oh, by the way, I need to have a look at your mental health strategy or psychosocial hazard compliance. So be ready, be on the lookout for those types of questions. They're going to look for three main areas. How well do you consult and communicate with your workers about changes that impact on their work, their ability to do their role? And they're not just looking for minutes of meetings, they're not just looking for newsletters or topical posters that go out. They're really looking for a feedback session, like engagement surveys, like focus group sessions, like talks within the team, like team huddles, and how well you've discussed it or how not well you've discussed it. So make sure that your consultation is very robust and it fits the purpose, and it's not just a tick the box exercise. They're also looking for risk assessments. Can you give me a show of hands how many organisations can produce in the next 24 hours a psychosocial hazards risk assessment? Yep, you can. Fantastic. Yep. So, they are going to ask for a copy of a risk assessment where you have identified what kind of psychosocial hazards apply to you as an industry and as an individual organisation. What kind of control measures do you already have in place to mitigate those psychosocial hazards? And have you actually identified the risk of not doing anything? So if you have identified that work demands is one of the psychosocial hazards because everyone's overworked, what control measures do you have in place to try and mitigate that as far as reasonably practicable? And not only that, what risk does work demand pose on people? So let's quickly go through that. What do you think are some of the risks associated with exposure to job demand time and time again?
People burn out.
Yeah, burnout. What else? Physical burnout is an individual factor. How do you what kind of risks pose to the organisation if the general workforce is burnt out all the time, or
Their work is not going to be as good.
yeah.
Their is going to decline.
Yeah, so their work quality is going to decline. They become, disgruntled. So there could be sabotage involved. So the risk is great, and that's the level of depth that you need to go into to find out what kind of risks are associated if the organisation doesn't do anything about managing these psychosocial hazards. All right, so let's have a look at some case laws. Very quickly on this one, this is as Adelaide Hills Council have been investigated as a result from a complaint from their union of possible psychosocial serious staff bullying and intimidation issues in the workplace. Still on foot, very new, investigation is still occurring. We don't know whether they'll be issued with an improvement notice, or we don't know whether they'll be actually going to prosecution straight away. You don't always have to have an improvement notice issued before you can be prosecuted for any breaches of the law. They had a mass exodus of staff. 49 staff resigned, including very high-level C-suite directors. So their turnover rate was 25%. The reason I put this up is this is a strategy for you. If you want to know which department or an operations area is not doing well, maybe have a look at staff turnovers in that one, or the level of absenteeism of your workforce in that particular organisation or that operations area, because that might give you some telltale signs as to do some investigations, supplement some more resources, get your HR team in there, get your work health and safety team in there. This is a very recent case, Cobra Management Proprietary Limited. I know it's not the same industry as you, it is actually a mining company, but the information as a result of the prosecution is exactly the same. A lot of the companies are now undertaking enforceable undertaking commitments due to the level of penalties that they're going to be exposed to if they are prosecuted under work health and safety laws. So Cobra just committed to $1.25 million enforceable undertaking. They have to spend that. They actually have to show transactional invoicing at the end of this program to show that. Now, they're going to ensure that they have mental health first aid leadership training. They're going to improve their fatigue management and workload management issues. So from the physical hazard of fatigue management, they found that the risk of people being burnt out and exhausted is too great. And they're also going to have structured psychosocial risk assessments to strengthen compliance to the law. So, because what they found was that when staff went to middle managers or their supervisors for support, they were not trained adequately to deal with psychological health and safety issues. So even though it's a mining company, that would apply to anyone in any organisation or an industry, wouldn't it? Yeah, so another very important case. Armstrong Creek School, I felt this is very relevant to you guys because we had a student in high school who had disability services support through NDIS and through their youth workers, unfortunately erupted into violence on one of their schooling occasions. And what the teacher decided to do was leave the student in the room while she evacuated the rest of the children outside. What she didn't realise, and on a side note, this is why your emergency management planning and crisis management planning is really important. When she evacuated to the hallway, it was a dead end. So the children were sort of stuck at the end of the hallway where there was a wall. They should have gone left and instead of right. And if you're challenged like me, I would have done the same, turning ways. So then the violent student came out of the hallway and physically assaulted a lot of them, including the teacher. She had 5 weeks time off work for physical injuries. But can you imagine the psychological impact on that teacher? And the students, yeah. So give me some examples of what she may come back with from a psychosocial hazard perspective.
Post-traumatic.
Yeah, post-traumatic stress. Any kind of trauma exposure can, re-trigger that event for her. Now, what happened in this case was they actually did have a system in place. They actually had a procedure in place to mitigate this. Every room had a phone, an emergency, those red phones that you see on TV shows. So she was to pick up that phone, dial reception, tell them like a code like violence, hang up. The receptionist will then dial all the other 3 executives in the school and get them to come, whoever's available to come. May not have been the perfect system, which obviously wasn't in this case. And what they found was, well, one, not every classroom's phone was working. So that's an issue. And 2, she wasn't allowed to use her mobile phone due to school mobile phone policy when it would have been much quicker. And 3, the receptionist is not always there because she might be on lunch or she might be making coffee. So when WorkSafe Victoria came in, they said, there's actually a better way of doing this. And they actually said, and it is reasonable for you to implement a better way of doing it. So their suggestion was, have a Duress phone line that goes to anyone, any 5 or 6 people, so that if someone's making coffee or someone's not at their desk, someone can still answer the call. And have a distinct ringtone so that we know that, you know how some people just ignore their phone like I do, especially when it's calling from school. When the WorkSafe Victoria investigated, they actually provided this advice. They said it would have actually been better if you did it this way. So they gave advice. So don't be afraid to ask your inspectors and investigators, what's a better way of doing them? Leverage off their experience, leverage off their information. Now in this case, the judge was very sympathetic and said, you did try. Well done, but here's your participation award and fine them $25,000 plus costs. Again, not an industry that you're working with. Department of Justice was prosecuted for providing a lack of procedures and support when it comes to any female correctional officers being exposed to bullying, harassment and psychological health and safety issues. Now, the problem with this is I'm sure everyone's going to go, it's a jail system. You're going to have criminals who's shouting abuse at you. So how do we actually manage this? That wasn't the actual issue here. The issue was that WorkSafe Western Australia went in and said, here's an improvement notice. We know how difficult it is. Here are some pointers on how you can improve your procedures. And we'll give you 18 months to implement these changes. Ample time, ample resources, ample advice. even after 18 months, they actually did not meet those improvement notice, even with extension. So basically the WorkSafe Victoria turned around and said, well, we're now going to slap you with a prosecution because you're obviously not taking this seriously. And they've even charged them under the Category 1 offence. And if you remember the penalty rates, the Category 1 offence, if you're found guilty, an organisation can be fined up to $10.7 million. An individual of that organisation can be fined up to, I think it's 3.2. So I don't know about you, but I don't have $3.2 million spare in my bank account. So this is why you need to take improvement notices seriously. So that's another case that I've put up there for you. All right, so while I've been given time to breathe, this is what we need to have in place when it comes to being able to meet your compliance. How robust and how fit for purpose are your risk assessments and your consultation procedures? How well do you progress those feedback that you get from surveys? How well do you actually have touch points with your employees about progression of those feedback that you got? Do your policies and procedures adequately cover the management of psychological health and safety issues? And I've given you another case there, Kozarov. This is a case where there was a very robust vicarious trauma policy in place to manage traumatic events, exposure to employees. But even though it was in place, when the middle managers were interviewed on why didn't you actually implement your VT policy, VT procedure, it was actually a really good one. The middle managers said, we didn't know it existed. So training, awareness, keeping up with all the procedural documents that we've got in the workplace is critically important because I actually had a really good one. So lots of food for thought for you to take away. But the one thing that I really do want you to commit to, and the level of commitment that I want to see you guys, do when it comes to compliance and when it comes to your work health and safety remit, is be the pig. Commitment is like a ham and egg sandwich. The pig was committed, the chicken was involved. So be the pig in your organisation. Commit. And on that note, can I introduce Elise Stone for Kutcher and Neil?
Every one of you here is connected to a workplace, and whilst from different industries and specialties, I think you'll agree that we all have one thing in common: payroll. It's a critical function that needs to be done right. With payroll regulations evolving and enforcement actions increasing, as we've heard this morning, businesses that fail to keep up risk financial penalties, reputational damage, and employee dissatisfaction. Today, I want to share with you my learnings from auditing payroll, including key payroll compliance risks, common mistakes, and best practices to ensure your payroll processes are accurate, efficient, and fully compliant. Today's agenda includes recent Fair Work findings, lessons from the past 12 months, common payroll errors we find during my team's work as auditors, key payroll controls, key features of a good payroll and HR system, and termination payments. Over the past year, Fair Work has ramped up its audits, particularly targeting high-risk sectors such as agriculture, building and construction, care, hospitality, and large corporates. And as you can see here, the numbers are staggering. 473 million in unpaid wages, 160,000 employees affected, and record-breaking penalties of 21.2 million in the last 12 months. Interestingly, over 17,000 anonymous reports were made by workers, triggering further investigations. This figure is up 19% from last year. I think no business is immune to this. Many of the risk factors and issues identified in Fair Work's investigations are directly transferable to any business, and it's important that boards and senior management address these risks in order to have confidence that they are compliant. The most commonly observed issues by Fair Work are lack of investment in payroll systems, expertise and staffing, as well as absent and inefficient compliance checks and auditing. Annualised salaries for award-covered employees being insufficient to compensate for all work actually performed, or organisations implementing a set and forget buffer, which fails to accommodate increases to minimum entitlements over time. Failure to properly map roles to correct classifications or job grades, incorrect system configurations, and manual or claims-based processes for entitlements. So how do these mistakes actually happen? We've seen firsthand how even well-intentioned businesses can sometimes get payroll wrong. Most errors aren't deliberate. They come from misinterpreting awards, misconfiguring payroll systems, or missing key compliance updates. During my presentation last year, I took a deep dive into some common issues we'd seen, and these are listed here on the slide. Whilst I don't intend on duplicating that speech, I wanted to draw your attention to some of the similarities between what we're finding in our work and what Fair Work is finding in theirs. See if you can spot them. I also wanted to call out a couple of items in blue. The common pitfalls with superannuation, for example, include allowances, reimbursements and bonuses are not correctly included or excluded from ordinary time earnings. Complicated awards and rosters can make it difficult to identify applicable allowances. Overtime payments, these are typically not considered ordinary time earnings, but there are some exceptions. And annual leave loading should be included in ordinary time earnings in most cases. With respect to leave entitlements, I wanted to highlight that incorrect annual leave entitlements are sometimes granted to shift workers. It's important to know that under some awards, shift workers are entitled to an additional week's annual leave, and when a shift worker takes leave, they should be paid the higher of 17.5% loading or their rostered pay. The good news is that these are preventable with the right controls in place. Payroll is one of the largest expenses for most businesses, and errors or fraud in payroll processing can lead to financial, compliance and reputational risks. To safeguard against these risks, there are 3 key areas where payroll controls must be strong. Ensuring payroll accuracy. So businesses need controls that flag errors before payments are processed. Key controls include payroll master file review. So perform an annual review of your payroll settings to ensure compliance with Fair Work awards, tax rates and enterprise agreements. Exception reporting and alerts. So set up automated alerts to flag for things like large unexpected pay increases, negative leave balances, or employees being paid outside of their contracted hours. Reconciliation of payroll data. Ensure payroll expenses match other financial records to identify any possible discrepancies. And prepayment reconciliation. Cross-check payroll totals against expected wages before finalising the pay run. Next, the key to compliance with Fair Work and super laws is to ensure payroll policies and systems are regularly reviewed and updated. Key controls include staying up to date with wage increases and award changes. Do staff know when changes occur? Is the master file reviewed after an update to ensure it's been processed correctly? Perform an annual boot test or better off overall test for above award employees to ensure that employees on individual contracts are still better off than the award minimums. Complete monthly super reconciliations. Cross-check your super payments with ATO requirements to avoid late payments and penalties. Best practice is really to conduct a compliance review every 6 to 12 months. Finally, payroll fraud can happen when there's a lack of oversight and poor internal controls. To prevent unauthorised changes or fraudulent payments, businesses must implement segregation of duties and strong approval processes. These could include no single person should have control over payroll processing or full control over payroll processing. Role-based access restrictions, so ensure payroll staff cannot modify their own salaries or change employee details without a layer of approval. Dual authorisation for payments. Payroll payments should always be reviewed and approved by a second authorised person. Maybe you could consider if this person even needs to be a member of the payroll team. Maybe somebody outside of the payroll team might be better placed. And best practice, conduct quarterly audits of payroll access and approvals to ensure policies are being followed. For organisations that have not conducted a payroll review recently, now's the perfect time to assess risks and implement improvements. Would your organisation pass an independent payroll audit today? Consider, when was the last time your business performed an assessment of payroll internal systems and procedures? Do your processes align to these best practices? Have you had instances of back payments and have you addressed the root causes? When did your business last review the payroll software's configuration? And finally, are you confident that your payroll system is paying employees correctly? If you can't answer yes to all of these questions, these best practices are the first steps in strengthening your payroll's integrity. Even with strong payroll controls, compliance is only as good as the systems that support it. A lot of the errors we see in audits don't come from a lack of human effort, they come from systems that simply aren't keeping up. Outdated payroll software, incorrect settings, or systems that don't integrate properly, these are things that can lead to compliance breaches. So what should a good payroll system have? Here are 5 features that every business should demand from their payroll system. Firstly, a payroll system needs to automate compliance. A good system should automatically apply the correct pay rates, penalty rates, and overtime based on the relevant award. Alert payroll teams about Fair Work wage increases, super changes, and tax updates before they take effect. If these things aren't automated, you're leaving a lot to chance or spending a lot of time manually checking, and that's a risk you don't want to take. Next, let's talk about security. Your payroll system should have role-based access controls, so only the right people can make changes to the payroll data, multi-factor authentication to prevent unauthorised logins, and audit logs, so every change in the system can be tracked. Your payroll system should proactively flag errors before they become big problems. Your system should alert you if someone has been overpaid or paid twice. Flag negative leave balances so employees aren't taking leave they haven't accrued. The next big one is reconciliation. A strong system should reconcile payroll costs with financial records so nothing can slip through the cracks. Provide variance reports so you can easily spot unusual wage trends. Finally, payroll needs to work seamlessly with time and attendance data. One of the biggest causes of payroll errors is incorrect or manual timesheet entries. Your system should include automatic shift rostering, making sure staff are scheduled within award conditions, and require overtime approvals, so extra hours are authorised before they're paid. At the end of the day, an efficient payroll system isn't just about processing wages, it's about protecting your business by reducing risks and ensuring accuracy. So let me ask you, is your payroll system helping you stay compliant, or is it leaving you exposed to risk? If you're not sure, again, now's the time to review. I wanted to finish today on briefly touching on termination payments. This is commonly one of the trickiest areas we find in payroll. Getting the tax treatment wrong, incorrectly classifying the type of termination, and not considering caps that affect tax rates. Termination payments are not one size fits all. Here's what you need to consider to get the payment right. So firstly, identify what payments constitute an employee termination payment or an ETP. Generally speaking, payments made on termination that are not lump sum leave payments are considered an employee termination payment. ETPs are taxed concessionally and are subject to caps and age of the employee. Redundancy payments are treated differently again, so it's important to understand the elements that make up an employee's final pay. Step 2 is when processing an ETP, you need to determine the type of termination. You must classify it as either a type R, which is redundancy or disability, or type O, which is most other things, which significantly impacts the tax rate. Step 3 is consider the employee's age. Their age at the time of termination determines how much tax to pay on the ETP. And finally, applying the correct tax cap. When calculating tax on termination payments, 2 key caps apply, the ETP cap and the whole of income cap. The best way to stay on top of these complexities is to have a clear termination payment checklist, automate compliance where possible, and always cross-check tax calculations before processing final payments. Practically, I've shown here on this slide how some typical components of a termination payment are treated. I won't run through these today, but you'll get the slides afterwards and be able to have a bit closer look. To wrap up my presentation though, payroll compliance isn't a set and forget task, it's an ongoing responsibility. The businesses that succeed in this space are the ones that proactively review their payroll systems, invest in the training of their payroll staff, conduct regular audits, and invest in the right technology. So here's my challenge to you. Review your payroll software. Is it keeping up to date with Fair Work and ATO updates? Audit your payroll controls. Do you have the right processes in place? And finally, check your termination payment procedures. Are you confident that they're being processed correctly? If you're unsure, I hope I've convinced you to take action. That's it for me, so thank you for your time this morning. Our next forum is on the 17th of June, as you can see here on the slide. I hope you will attend. We'll send some more information out post this event. There'll be slides coming out after today's event and a video as well for anyone who wanted to watch it again. But finally, I just wanted to say thank you for joining us today. And if you've got any questions, please feel free to come and talk to any of our team members or anyone who presented today for more information.